But will those tribunals
judgments will be delivered?
Will those tribunals not be challenged since they were set up by the acting Chief Justice?
No, no. Again, that is not correct.
Okay.
The members of the Election Petition Tribunal are constituted by the President of the Court of Appeal.
Okay.
The Chief Justice or the acting Chief Justice merely performs the oath of office on them. No more, no less. So we should get these things right. But I will say that.
You talked about the backwardness of this.
I will say that. Yes. I can tell you, in the majority of African countries, there are constitutional courts to deal with election disputes. And those matters are dealt with speedily. 14 days, 21 days. In our own country, we used to have a limitless period, sometimes up to 4 years. By the time we're having another election, some of the election petitions are still in court. That's number one. Number two, unlike in the past, whereby election petition tribunals and judges try disputes arising from election, we recommend the trial or the discipline of officers who engage in electoral malpractice. These days, our courts simply behave like Pontius Pilate. Furthermore, we have imported very reactionary doctrines into our electoral jurisprudence, such as prove beyond reasonable doubt. You are saying the election has not been properly committed, and these allegations are said to be criminal in nature. So you must prove beyond reasonable doubt, not on the balance of probability. Who won the election, who lost the election. They ask you to come and prove it like a criminal offense. Furthermore, you are not just going to allege failure or refusal on the part of the electoral body to conduct the election in accordance with the law. The onus is on you to show that non-compliance with the law has materially affected you. Apart from those who contested the election, every Nigerian, including thousands that may have been disenfranchised, lack the local standard to challenge an election. You can't say, oh, I wasn't allowed to vote. I'm challenging the election, or you must pay me compensation. They say, sorry, you have no local standard to challenge the election. Furthermore, when you allege that figures have been inflated, you have to bring the actual figures and what has been inflated. So whichever way you look at it, there are insurmountable legal hurdles for petitioners. I know colleagues, very respected colleagues, who will never handle election petitions. I mean, who will never handle cases for the petitioner. They would rather handle for the respondent, so that they just go to court and raise technical objections to the petition. We have cases where the courts have held that, yes, you have alleged that the election was manipulated, violence took place. You have to prove how such violence, how such manipulation has affected the election. And our courts always end up with the theory of substantial compliance. That when you look at the totality of the election, 120,000 polling units, you're only challenging maybe elections in about 500 or 1,000 units. So that cannot materially affect the result of the election. So these are the problems with our electoral jurisprudence. Unfortunately, for 16 years, under the PDP government. The democratic forces in Nigeria, progressive forces in Nigeria, the human rights community, and other stakeholders try to impress it on the government to change the electoral jurisprudence, to embark on serious fundamental electoral reforms. Those pleas were ignored. We are also in that era now.
Yes, because
where the ruling party
has refused also.
Has also refused to embark on genuine electoral reforms. And of course, if for any reason the ruling party is defeated in an election in future, oh, you are going to have this type of allegations raised by the PDP now, by the APC then, but hopefully some new democratic forces should have taken over the process. It can't go on like this indefinitely. No nation can continue to toy with its destiny as we are doing. Of course, the West panel made profound recommendations. They were ignored, including
the electoral offenses
of tribunal
and commission.
President Jonathan set up the Amelemu, post-election violence in 2011. Again, very serious recommendations were made. Again, including the electoral offenses tribunal. All the recommendations were ignored. President Muhammadu Buhari set up the Kenamani Committee, which reviewed all the previous recommendations and added new ones to reflect the current situation. Again, even the report has not been debated at all. So it's not about looking for new ideas. Those recommendations are on ground, but they are gathering dust in the archives of the government. Not to talk of several judgments of our court that have indicted the electoral process and called for reforms. So what has happened over the years has been an attempt by the INEC to update, take a few of the recommendations, turn them into guidelines. But that is not sufficient. That's why we're in a mess.
Speaking of a mess, I want you to talk a bit about the militarization or seeming militarization of the process, the involvement of military or people in military uniforms or people said to be military, depending on who it is that is doing the talking. The military, of course, has denied it, that it had any role in this.
No. I don't think that would be correct to say, I think that was an afterthought, the denier. But the denier is contradictory. Before that denier by the Army headquarters, the Chief of Army Staff, the Army authorities had set up a panel to investigate the role of its own men, the role of its men in the election in Rivers State, where allegations were made. If you now say, these guys that were paraded or, being investigated are not members of the armed forces, there's a problem there. In 2014, and this is the tragedy of it all. In 2015, the Chief of Army Staff, General Yusuf Buratai, set up a panel of inquiry headed by Major General Yebade
to look at the Ekiti,
to investigate the militarization of the Ekiti governorship election in 2014, where the then candidate of the PDP for that election, Mr. Ayodele Fayoshi, was alleged to have been commanding a general in the army. All the military officers and other military personnel indicted in that probe were flushed out of the Nigerian army. In addition to that, there are not less than 5 judgments of our court which have declared that the armed forces have no role in our elections. Curiously, these cases were filed either by the candidate of the presidential candidate of the CPC or APC, General Muhammadu Buhari, now our president, or individual members of the APC. One of the cases was filed in Lagos by Honorable Femi Gbajabiamila of the APC, where the Federal Court held that it is illegal to deploy troops to conduct, in the conduct of election. There was also a judgment of the Sokoto Federal High Court. In fact, in one of the Buhari-Obasanjo cases, a former president of the Court of Appeal, the Honorable Josiah Issa Salami, said, our political class may be intolerant, but having eased out of the military out of our politics, we should try as much as possible to keep them at bay. They shouldn't get involved in our electoral process. The totality of these cases and the major pronouncements of our court influenced the National Assembly to amend the Electoral Act on 27th of March 2015 to the effect that the INEC shall assume the power of deploying the security forces during elections in Nigeria, provided, and I'm quoting the law, that the armed forces shall be restricted to the transportation and delivery of election materials and protection of electoral officers. There is no law in Nigeria that allows any member of the armed forces to take command or guide a collation center. No, it's not part of our law. In fact, it's contemptuous of the judgments of our courts. But militarization does not end with armed soldiers. When you also use the police and thugs to terrorize voters, you're also militarizing the electoral process. And thugs commit atrocious offenses during our elections. But they are all protected by godfathers in the political parties.
But then why was there so much brouhaha when President Buhari asked the security forces to deal ruthlessly? I believe the comment he made led a lot of people to assume that he said that anybody who snatched a ballot box at a center would pay for it with his life. And a lot of people were...
I think I think it was the way the president spoke. If it's about invoking the law or saying that the full weight of the law would descend heavily on electoral offenders or ballot box snatchers, I'm not sure. There shouldn't have been any problem. But where it was said that in dealing with those who snatch ballot boxes, right?
Yes.
They may lose their lives. That was a license, a presidential license for extrajudicial killings by our overzealous police, security forces. And I think that was the area. But nobody criticized the threat to deal with ballots, box snatchers, or other electoral offenders. But again, the law is very clear on it. There are provisions of the law to deal with all categories of electoral offenders. But our problem is the impunity and the fact that those who commit these offenses are granted immunity by the government. By the government. I do hope this time around, since the Electoral Offences Tribunal has not been created, has not been allowed to be created, the INEC will invoke its powers under Section 150 of the Electoral Act to prosecute all the electoral offenders that have been arrested by the police and other security forces.